Hello, this is the AO3 video for murder. So this is evaluation. If you get asked a question on murder, as in an essay question, you need to do the 10 AO1 points, see my previous video, and then you need to discuss all of those points. You need to look at, is the law satisfactory or not? Now, this is not an exhaustive list of points. You may well come up with your own evaluation points. Absolutely fine. Think about the strength of your argument and actually, debate that in an essay. Think about, well, this is not really that strong a point because, and then go on to explain it. So some of the key evaluation points that I have picked out that I thought are worthy of discussion. The first one is the fact that murder has a mandatory life sentence. So this means the judge has absolutely no flexibility. They have to give you a mandatory life sentence. They have to set a minimum tariff. Now, they may not want to do this because you may have had a fairly good motive to kill somebody. It could be a terminally ill relative. They ask you to help them die and you kill them to put them out of their pain. Unfortunately, in this country, that is murder. Euthanasia is not legal. The jury may have convicted somebody, perhaps that they shouldn't have done. So Peter Sutcliffe, the Yorkshire Ripper, he was a paranoid schizophrenic. He had voices in his head from God telling him to murder people. And the jury denied him the defence of diminished responsibility and insanity. And, the judge might not have agreed with this, but you can't challenge a jury decision unless the jury have been nobbled, that classic phrase. There's also, talking about the sentence for murder, there's also a criticism that life doesn't mean life. Well, there are a couple of points on this. Firstly, life is life. It just doesn't mean life in prison. So a life sentence, you are on licence for the rest of your life. So the judge sets a minimum tariff, so 15 years starting point. Let's say you get 15 years. After 15 years, you're eligible for parole. Doesn't mean you're going to get out. However, if it's deemed that you are safe enough to be released from prison, then you will be released from prison. What then happens is you are on licence for the rest of your life. So if you commit any other crime, you will be hauled up in front of the courts and you will end up in prison. Common misconception that life is 25 years. I hear that a lot for students who are starting off, but You now know that life is not 25 years. Okay, so that's the first point. Life sentence, mandatory life. There's a lot you can say about that, lack of flexibility and so on. Second point is the fact that you don't even have to intend to kill somebody. So this second point, intent to cause GBH. So if you intend to kill someone, it's murder, but equally if you intend to cause serious injury, it's also murder, which you could argue is actually quite unfair because a defendant may never have foreseen death as happening, yet you are convicting them of the most serious offence of murder. So it makes the offence of murder very wide. It's good because it ensures that violent people who intend serious injury are convicted and locked up in prison. Also, proving intent to cause serious injury is easier than intent to kill. That's quite a difficult one for the prosecution to prove in court. Therefore, again, it ensures violent people are being convicted. The third point I want to look at is being a human being. What is a human being? So it seems very unfair that if you stabbed a pregnant woman in the stomach, let's say she's 8.5 months pregnant, you stab her in the stomach and she gives birth and the fetus dies, or the fetus dies inside her when you stab her. That is not murder because the fetus is not a human being until it's been expelled from the womb. The defendant can be convicted of child destruction. It's a horrible sounding offence, but only 16 people in 11 years have been convicted of this offence. So it's much less likely. they'd probably be convicted. Well, I'm sure they would be convicted of the actual stabbing, so that would be GBH. But it just seems that they're getting away with quite a lot if they're not charged with murder. Looking at the case of Bland, so Bland, the doctors wanted to stop treating him. He'd been in a persistent vegetative state for 3 years. And I think it's sensible that the court said, act in the patient's best interest, you can stop feeding him. So doctors, yes, the sanctity of life is very, very important. However, they do act in the patient's best interest, and I think it's good that the law protects this. Fourth point that you could discuss are the defences available to murder. Now, the use of defences is actually quite inconsistent. You've got full defences, you've got no defences, and you've got partial defences. So this is a good point to discuss. I appreciate we haven't yet studied defences, but there's some stuff you can put in. So first of all, self-defence is a full defence to murder. So the defendant will be acquitted as long as they have used reasonable force. So you can kill someone and you will not be a criminal. And maybe discuss, is that good? Is that bad? I mean, you have killed somebody, but equally you did it because you acted reasonably in the circumstances. So maybe that's right, that you were defending yourself or others. Self-defense is a bit misleading because it doesn't just have to be you, it can be other people that you are defending as well. So self-defense, full defense. You've then got a couple of special defences only available to murder: loss of control and diminished responsibility. We'll look at those later on in the course and through a series of videos. Loss of control and diminished responsibility end up with murder being reduced to manslaughter, so it's a partial defence. Those two defences are only available to murder, which is interesting. Why aren't they available to other crimes? That's something to think about. You've then got some defences that are not available to murder. For example, duress of threats. There's a case called Wilson. Now, Wilson was 13 and his really violent, horrible father said to him, "I'm going to kill you if you don't kill your mother." And he's 13. Remember, you're a criminal from the age of 10 in this country, very, very low. He's 13. His violent father has threatened him. He kills his mother. He claims duress of threats, but the courts say, no, sorry, duress of threats. The law says duress of threats is no defence to murder. You're over the age of 10, therefore you are a murderer. And I think that's really unfair, so maybe that's something. If you want to argue it's fair, go for it. If you want to say, well, killing is always wrong, then go ahead, justify it. It's fine. You can have different opinions. The next point, euthanasia, is quite a good one to discuss. Don't kind of get carried away too much with this point. It's not a euthanasia essay, but it's well worth discussing the fact that doctors can withdraw treatment, so they can stop treating, but they can't actively kill someone because they would be guilty of murder. So euthanasia is still illegal in England and Wales, in fact in all of the UK. Judges will never ever change the law on this. So you kind of think, well, what's the point of people bringing mercy killing cases to court? The point of it is to draw the public's attention to the issue and also to draw Parliament's attention to the issue. But I think it's such a huge law that would be changed here that judges feel it goes beyond their role, because remember, judges are meant to apply and interpret the law. They're not meant to make the law. So really, they know that this is too big for them to change. It would have to be something that Parliament did. So euthanasia, worthy of discussion. In Belgium, they let children who are terminally ill make the decision to end their lives if they wish. So that's quite interesting. Perhaps research some of that. The other point to always put in an essay is about proposals for reform. These generally come from the Law Commission. So remember, the Law Commission writes a report and they evaluate the law. They look at all the problems with the law. So if ever you want some essay help on, what are the problems on the law, try and find a Law Commission report and the essay is written for you, kind of thing. So the Law Commission produced a report in 2008, and they suggested that murder should be in 2 tiers, which kind of is in America. I think there's like 3 tiers. So they said first degree murder should still have a life sentence, mandatory life, and it's where you intend to kill. But then they said, well, let's have second degree murder, where you intend serious injury, but instead of mandatory life, let's have discretionary life. I think that's quite a good idea, because then you are separating murder into the really bad one, where you intend to kill, and then the bad one, but not quite as bad, where you intend serious injury, and that's reflected in the sentencing. So, good flexibility there, but as of yet, nothing has changed. So just remember, the Law Commission produces this report, they pass it on to Parliament, and then if Parliament want to change the law, they will announce it in the Queen's speech. But as of yet, it's still murder, whether you intend death or whether you intend serious injury. There are lots of other points you could talk about. I mean, you could say the fact that there isn't an Act of Parliament that contains murder, so it's common law, it's been developed over the years. Perhaps we need an Act of Parliament, but equally you could argue against yourself there, and you could say, well, the law is clear, it's worked very well in practice, has it really caused any injustice? You would perhaps conclude on a point like that as to whether you think it's working well in practice and whether you think it actually needs reforming. So try and balance it up. Think, right, these are the bad points about it, these are the good points, but overall, what is my final judgment? Do I think, if it's a yes or no answer, do I think overall the law on murder is satisfactory? So I'll let you decide that. You can conclude however you want. You're not going to get it wrong for putting your opinion at the end of an essay. So lots and lots of points there for you to think about. If you want to talk about any of the cases individually in a bit more detail, go for it. Self-defense, Tony Martin, maybe you think that was okay, he didn't use excessive force. In America, you can shoot people who come into your home or onto your property, whereas we don't have that in this country. Lots of things to consider.